What is mooting?
Mooting is essentially when barristers appear before, typically an appeal court, in order to toss over a judgment that has been previously made in the lower court, and they're now appealing against that. And after they've made that particular case, the other side, the respondent to that particular appeal, will make their case as well. In other words, there's no witnesses. It's just one barrister who will make a particular point, followed by another barrister on the same side making their second point, arguing a particular point of law to say why an appeal should go ahead. After they've finished their two presentations in relation to the matter, the other side will be asked to respond. They then have the senior counsel make the first point, the junior counsel make the second point, and typically they're matched so that the matter is evenly poised. And then the judge will listen to both of those arguments and make his or her judgment.
So what is the difference between a mock trial and a mooting competition?
A mock trial involves witnesses. A mooting competition does not have witnesses at all. It's typically an appeal case where there's a point of law, and typically the point of law will be easily discernible with maybe two appeal points. And the first barrister the first barrister of each side looks at the first appeal point. The second barrister of each side looks at the second appeal point. But the important thing is that you'll have the whole appeal on one side heard first, then the whole response on the other side second. In other words, unlike a mock trial where you're going backwards and forwards between witnesses, etc., there's one side for the appeal and one side for the respondent. And that's the difference between the two.
What skills do I need to compete in a mooting competition?
Well, you need to have the good skill of preparation. My one problem in relation to listening to moots is when someone looks like they're not quite on top of what has to happen. You really have to know what the appeal point is and then the precedents too that would be on your side. So you'll be looking at a couple of precedents to say, we want the judge to follow these precedents because these fit entirely. But there might be a couple of other cases which are never exactly the same, which tend to come to the other conclusion, at which point you'll have to have thought about those precedents and say, I'd like to distinguish those precedents and say these don't apply here, but these precedents do apply to our side, and we'd like Your Honour to favour that particular precedent in giving us the appeal point. So the skills you have to have is to be completely on top of your argument. Secondly, to make eye contact with the judge. Thirdly, to speak in complete sentences in an articulate fashion, so you're not mumbling, you're not tossing out ideas that are going nowhere. But importantly, and this is the most important one, you will be stopped and harassed by the judge. You keep smiling, you look like you're actually enjoying the interactions and not being bothered by those interactions. And I've seen cases where a person hasn't got through their first sentence before the judge has said, wait a minute there, Mr. Jones. I think they're actually going off on the wrong tangent here. If it pleases Your Honour, thank you for making that point. I understand where Your Honour is coming from, but what I'd like to say here, in other words, very courteously, turn the matter back into the submission you're making. That is the most important thing you do in a moot. Your ability to respond to the fact that judges are trying to catch you out.
Can you please explain the role of senior counsel, junior counsel and a solicitor in a mooting team?
Well, typically the senior counsel will be the first one to speak, and that's probably the most important of the appeal points. Junior counsel tends to get the second appeal point. It might be as worthy, but typically it's not the main one, and the solicitor is listening the whole time to hear what it is the judges are looking for, and if you need to have some adjustment before your final submission, the solicitor will help to make sure that that particular point is made. Plus, the solicitor is a sounding board when the three of you are getting together to say, what is it that our case is going to be based on, what precedents will be used, how will we distinguish the cases that go against us, and what's our final submission going to be.
And what are the skills needed for a good, like a top-level senior counsel, junior counsel and a solicitor?
Well, a listening skill for the solicitor, that's probably the easiest thing, plus the the ability to have the confidence to say, I think we should go down this particular path. As I said, the solicitor is kind of a sounding board to help the other barristers work through the way in which they're going to be responding. But the key skill is to keep your brain active while you are arguing, and you're not arguing with the judge, but while you are challenging the judge. So if the judge says, I don't like that argument, Mr. Treworthy, I think in these circumstances the case might have gone this way. If it pleases Your Honour, our submission is the case should not have gone that way because blah, blah, blah. In other words, be very polite, be reasoned, not hesitate, and be completely on top of the argument you're going to be making in order for you to give the confidence to the judge that you know what you're talking about. Now, typically, a judge will be putting these arguments to you in order for the judge to understand the nature of, one, where your argument's coming from, and what's going to happen when the other side starts saying these things, and how you're going to counter them. In other words, you may get a chance, not so much in too many moots at the high school level, but you may get a chance to have a resubmission if there's something that's being said on the other side, but not typically. In other words, you have to be ready to hear what the other side is thinking about because the judge is going to put that to you to make sure you're completely on top of your argument.
So I like being a barrister in a mock trial competition. Should I take on the role of senior counsel?
If you like speaking and you like talking to judges and you can think on your feet and you're confident with your ability to articulate and you enjoy the cut and thrust of public debating, yes, if you like mock trials, you like being in a mock trial as a counsellor, as a barrister, then yes, you'd love to be a counsel in a moot as well.
We've received the case brief. What should we do next?
I think the best thing to do is to read the whole thing out aloud together, and only when you've read the whole thing that you sit down and say, right, now what is our case theory? What is it we're going to be putting forward? What do the precedents say? These are the precedents that help us. These are the precedents who don't help us. How can we highlight the points about the ones that do help us in order to articulate those? How can we distinguish those that don't help us so we can distinguish them, get rid of them and say, Your Honour, we don't want you to follow those particular cases. At that point, you then understand the main point you're going to be doing, whether it's a civil case or a criminal case. At that point, having decided exactly what your case theory is, what your main point is and the circumstances, you can then start to dissect how it is you're going to be articulating that. But yes, get a real feel for the case first, toss it around, and then start writing down what you're going to be saying.
What process should my team follow if we want to win our moot?
Be well prepared. There's no question about that. I have been in many court cases, real court cases plus moot cases, where people are asked a question and they start flurrying around to look at the facts or look at their notes or look at the case. The best ones to win a moot have got it in their head already. You're not going to have it in your head unless you've been well prepared. So someone says, or the judge might say, is that exactly what happened on this occasion? And you'll come straight back and say, yes, it is, Your Honour, because here's what happened, bang, bang, bang. If all of a sudden you start thinking, oh, gee whiz, I might not be right about that, I better go and look at my notes here, and you're flurrying around, the solicitor's looking over your shoulder, immediately I'm thinking as a judge that you're not prepared well enough. That's the number one thing to do. Plus, to sound confident, plus to look the judge in the eye, plus to typically refer to your learned counsel next to you, my learned junior, my learned senior. Make comments about that to show that the two of you are on all fours together. You're actually articulating these arguments together. You're basically holding your line together, and then look across, maybe disparagingly, at the other side from time to time and say, my learned friend. You always refer to them as your learned friend, even though you don't like them at all. And of course, they're always learned, even though you think they're actually stupid. My learned friend over here, sorry, you would say something like, my learned friend has made the point, Your Honour, that such and such. But with respect to my learned friend, we would put a counter argument here. In other words, always be very, very confident in talking about your learned junior, your learned senior. Everyone's learned. Don't say the judge has learned, but yes, you be very courteous. Judges like that. When it shows that you're not taking these things personally, you're arguing for your client.
What are the biggest mistakes mooters make when competing?
The biggest mistakes is for them to suddenly think that they are going down the wrong tack, or they have got their facts wrong, or it looks to me like they haven't been prepared. You really got to be completely on top of it. The other big mistake would be to not use the court etiquette, not use the term Your Honour, not be respectful with the other side, my learned friend, even if he's not or she's not your friend, be very respectful of the other side, be ready to answer a judge's question with respect and to push back against what the judge says. After all, the only reason the judge is putting this to you, which is a counter argument, is to see how you respond. Not because he doesn't like you or not because he thinks you're stupid, but in saying, but surely, Mr. Jones, wouldn't you have said this was the case? With respect, Your Honour, our case is precisely that he wouldn't have expected that. In other words, you're articulating it, you're being very nice, but you're completely on top of your facts, you're completely on top of the law. That impresses a judge that you're well prepared, you're articulate, and you're respectful.
And how do competitors refer to cases when making their submissions?
They typically would refer to a case by its two names, and typically to show that you're well prepared, even though there's a versus or a V sign in the middle, you would actually use the term and. So to take a famous case, Searle versus Wallbank is a famous case on negligence. You refer to that as Searle and Wallbank. Judges like that. It shows you've sort of been around for a while rather than Searle versus Wallbank. Wallbank, you say. Your Honours might refer to or would be familiar with Searle and Wallbank. We would distinguish Searle and Wallbank in this case, so that's how you would refer to cases. But yes, use both the cases. If it says R, which typically means Regina or Rex, Queen or King, don't forget to use the term Queen or King rather than the term R. So you'd say, in the Queen and Flanagan, Your Honour, I refer to that particular case. Don't say R. Just make sure you got the pronunciation of the name correct as well.
So if you talked a bit about this, but if the judge interrupts, which happens a lot before you've even got 30 seconds through, just some more points on how to manage that situation.
Expect it. In fact, you can probably rehearse it. You could actually be at home and get your parents or your siblings to kind of banter you so that you don't look annoyed, you don't get flustered, you're almost expecting it. In fact, in some respects, you'll probably anticipate what the questions are going to be. And you might want to have a little note somewhere on the desk in front of you because you know what the objections are. Because essentially the judge is going to be putting to you what the other side has said or is going to say, depending on which order you're in. And so a judge will really be impressed in a moot when you immediately come back with the particular response or the retort. So you're 30 seconds into your submission and the judge says, but wait a minute, Mr. McCann or Miss McCann, surely this is the case. Look like you're relishing that question. If Your Honour pleases, I understand that in fact my learned friend will say that that's the case, but I put it to you that in these circumstances, and sound confident in that. In other words, look like you're relishing that rather than saying, Your Honour, I'm getting to that, or stop interrupting me. You'd never say that, of course. But you're saying, you look like you're actually enjoying the fact the question has been asked because it allows you to articulate another point of view. That is what impresses me when I'm looking at a moot.
And further to that, if the judge is literally pummeling or barraging with questions, like question, what skills does the barrister need?
The skill is to remain calm. The skill is to look like you're enjoying it. The skill is to say, with respect, you use that phrase, with respect, Your Honour, our point is exactly what you're asking, but we'd ask you to consider the submission to the opposite point of view. And here's that submission again. Suddenly you get another question. You stop immediately, respectfully listen to the judge and say, the point you make, Your Honour, is a valid one. However, we would disagree with the way in which you've interpreted that phrase. That phrase could be interpreted in the way in which my client interpreted it, which was X, Y, and Z. Another question. The interpretation, Your Honour, that my learned friend has put in his submission is a valid one, but what I'm asking you to do is to consider it this way. In other words, respectfully looking all the time, looking at the judge in the eye rather than flustering down with your notes, because you're completely on top of what it is that judge is going to be asking you.
Should I only compete in mooting if I want to study law in the future?
No. Mooting does give you all those skills about being articulate, about arguing respectfully, thinking on your feet, and learning to speak publicly, which in this day and age is a very, very good skill to have. If you do it particularly well and you're having a cup of tea afterwards and the judge is having a cup of tea and the judge says to you, my goodness me, you're very good, you should consider law. If he or she says that to you, consider law.
And to finish, as a judge, could you give your top 3 tips for mooting success?
My top 3 tips are: 1, make sure you're completely on top of what it is you're arguing. Nothing worse than a judge looking or testing a particular idea and finding the barrister floundering. The barrister should always know what he or she is talking about. 2, be confident. Be confident. In other words, look particularly like you're enjoying the fact that someone is pushing you for these particular arguments. And 3, make sure that you're respectful in everything you do. My learned junior, my learned friend, with respect, Your Honour, Your Honour's point is well made. However, what we are submitting, etc., in other words, the way in which you are cooperating with the court and articulating your case is completely respectful and completely confident. If you do that, the judge will love your particular team.